Sharon Hancock, and today I'm sitting with attorney Jeffrey Frank to discuss serious injury cases. What causes a herniated disc?
A herniated disc can be caused by a myriad of different events. It can be caused by a sports figure throwing a football. But the way we see it in our practice is from a traumatic event on the human body as a result of an accident, such as a slip and fall. Someone who slips and falls on a foreign substance on the floor of a store. It can be caused by an automobile accident case. For example, somebody is rear-ended in their car and is injured. It can also be caused by such things, in my recollection and practice, of a box falling off a shelf onto someone's head from a store. I can recall it happening where a chair collapsed under someone, fell to the ground, and the disc was herniated. It's interesting to note that a herniated disc is not always apparent immediately. Sometimes a doctor treats conservatively, and it's only after repeated attempts at remedies do they do more sophisticated testing, such as an MRI, and realize sometime months down the road that the disc is herniated and that a more significant type of aggressive care is needed, and it will result in surgery sometimes. The most important thing to keep in mind, however, is that a herniated disc is a very serious injury.
Can I sue on the grounds that I was not warned about the risk of spinal cord injury?
A doctor will have to warn of anticipated risks of the specific procedure before he performs, for example, surgery. And typically there'll be a written consent form which contains all the anticipated risks of the surgery. In that case, you would see a doctor in his consent form advise the patient of the risk of spinal cord injury. Where we do see spinal cord injuries are in medical negligence cases sometimes, where there's a failure to warn. In that case, the doctor, in his advice consent to the patient before the surgery, would have to warn of the anticipated risks of the surgery. Where that's not done, and there is such an injury, there is the potential to bring an action for that.
How much is a spinal cord injury worth?
Valuation of spinal cord injuries varies significantly from case to case. Such factors which influence the value of the case is, of course, how significant is the spinal cord injury. Some spinal cord injuries are less serious than other spinal cord injuries. Obviously, the more significant the injury, the greater the value of the case. Other factors which are critical are: what is the lost wages involved? Does the individual have significant past lost wages? Will he be able to work in the future? Or will he need vocational rehabilitation to transfer to a different occupation? Other factors are: how much are the medical bills that have already been incurred? And how much are the medical bills that are anticipated in the future? One should be inherently wary of any attorney that gives a quick evaluation and dollar figure of the value of a spinal cord injury without a thorough evaluation of the medical bills, the injuries, lost wages, and all other facts of how the event affected the injured person's life.
What is wrongful death?
Wrongful death is the type of legal action which occurs when someone's death is caused wrongfully. By wrongfully, I mean the situation where someone dies as the result of a third party's negligence or intentional acts. It could also occur through a product defect type of case. The important thing to remember is, in a wrongful death case, is that the death occurs through some other party's wrongful acts. The law specifies which heirs are permitted to claim in a wrongful death action. All such heirs must be brought into any wrongful death action to bring that case to a successful conclusion.
Is there a statute of limitations to file a wrongful death claim?
Yes, certainly. There's always a statute of limitations to bring any type of civil action. However, it's important to know other factors before one can answer that question. Is this a case involving the defendant being the state? Is it a case where the defendant is the federal government? Do we have a case where the injured person is a minor or is mentally disabled in some way? Those are things which affect the time period for the running of a statute of limitations. Bring the facts of your case to an attorney who can examine it and tell what the specific statute of limitations is for that particular case and those facts.
What can I expect at a wrongful death trial?
Both sides will typically designate expert witnesses on issues of liability and damages. In other words, the injuries that led up to the wrongful death and any potential defenses that there are. Once all discovery is complete, sometimes the parties will agree to mediate the case. Mediation is the process by which both sides will appear before an independent mediator who will attempt to facilitate the settlement of the case. If mediation fails in settling the case, at that point, the case will be set for trial. At the wrongful death trial, first the plaintiff puts on its case. The plaintiff will call all its witnesses to establish liability, causation, and damages. Such witnesses are, for example, the heirs of the deceased individual, how the injury occurred. Expert witnesses will be called. After the plaintiff puts on its case, then the defense has its opportunity to rebut whatever occurred during the plaintiff's case. The defense can call witnesses to attempt to negate the issue of liability, causation, and damages. After that, the plaintiff gets its opportunity to respond once again to what was said by the defense. At that point, the case often goes to the jury, and the jury will make its decision.
Is the damage from a brain injury always permanent?
That question is more appropriately answered by a doctor, a specialist, typically a neurologist. However, I can speak from my personal experience, and in the cases that we handle, the answer is yes, that damage is typically permanent. Now, it may be readily apparent in normal conversation, or the brain injury may not be readily apparent in normal and casual conversation. That's the reason we have our clients see neurologists and neuropsychologists to be able to document the nature and extent of the brain injury and be able to prove that injury in a court of law.
Can a person with mild TBI have problems many years later?
Absolutely. Sometimes TBI can improve, sometimes it can get worse. On other occasions, it remains the same, but the injured individual learns to cope with their disability so that it may not be more noticeable to the general public. That's why the nature and extent of the traumatic brain injury needs to be evaluated by experts with experience in this particular area, such as neurologists and neuropsychologists. Only those experts can determine the true effects of the traumatic brain injury and determine what is the long-lasting effect over the person's lifetime.
How can I best prove a brain injury in court?
A traumatic brain injury will be proven up in much the same way as any type of injury is proven up in court. It's done through the introduction of testimony of expert witnesses. Expert witnesses in a brain injury case typically will be a neurologist and a neuropsychologist. There will also be tests such as CAT scans. There will also be written tests performed by the neuropsychologist. The neuropsychologist and the neurologist will work together to formulate a diagnosis and determine the long-range effects of the traumatic brain injury. That is the best way to prove up a traumatic brain injury case.